All right, welcome to my YouTube channel. So today we will talk about jurisdiction. Today is for jurisdiction. I am talking to my undergraduate students, my law undergraduate students. Most of you are in year one. Most of you are even in year two. Probably people that entered through direct entry. But there are some words, there are some terminologies that you still need to abreast yourself with. There are some terminology you still need to know in order to succeed in your studies in this law, in order to succeed even as a lawyer. So your oblivion of these terminologies would affect you really hard. I mean, if you do not understand the meaning of some of these terminologies. And today we'll be looking at jurisdiction. We'll be breaking down jurisdiction. Most of you have been hearing jurisdiction. Most of you don't know the meaning of jurisdiction. Most of you have been hearing people use the meaning, use jurisdiction in a loose sense, but you still do not know the meaning of jurisdiction. Most of you know the meaning of jurisdiction, but you don't know the pecs inside that term, and you wouldn't probably know where to use them. Now, this is it. First of all, when we talk about jurisdiction, we are talking about the powers of the court to hear a particular matter. So when you want to sue somebody, when you want to charge somebody to court, you will first know which court has jurisdiction to hear this matter. You cannot just come and enter any court and say you are charging somebody. There is something we call territorial jurisdiction. Territorial jurisdiction means, is it possible that if somebody does something, or if why you want to sue somebody was done in, let's say, Imo State, can you now go to Lagos State to sue the person? We also have what we call subject matter jurisdiction. This particular thing, contracts, for example, can I go to the magistrate court to institute the action? Can I go to the Federal High Court to institute the action? Supreme Court is the highest court. Why am I even wasting time with all these small courts? Let me just go straight to the Supreme Court and institute the action. These are what you will have to determine first. And how you determine these things is to know the court that has the appropriate jurisdiction to hear the matter. Then we now have what we call original jurisdiction and appellate jurisdiction. Now, what is original jurisdiction? Original jurisdiction is the powers of the court to hear a matter for the first time. Origin. Now, why appellate jurisdiction is from this court that we are in now, where do we go next? All these things we will look at. First of all, let us start first, the jurisdiction. What is jurisdiction? And how do we know the court that has jurisdiction? How do we determine jurisdiction? Now, jurisdiction is the powers of the court to hear a matter. Very good, you know that. Now, if I have a case, how do I know a particular court that has jurisdiction? We will look at the laws. We will look at the laws, we will look at the constitution. First of all, we will look at the laws establishing those courts, and we will also look at the rules of those courts in order to know the courts that have jurisdiction. For example, there are some matters that cannot be taken to a state high court. There are some matters that should be taken straight to the Federal High Court. And you will see those matters in section 251 of the Constitution, Federal Republic of Nigeria, 1999 as amended. I don't know if you know how to open your Constitution, but I will still teach you that later. So when you go to section 251, you see the list of things that the Federal High Court has jurisdiction in exclusion. Listen, in exclusion of every other court, which means you just carry one of the subject matter there. Let's take, for example, something that has to do with drugs and poisons and all that. And you now go and institute your matter in state high court instead of the Federal High Court. The state high court will strike it out because they do not have jurisdiction. When I mean exclusion of every other court means that it is only the Federal High Court that has jurisdiction to hear that matter. No other court. Subject matter jurisdiction. What is the subject matter? Which court are we going to? Which court can we go to hear this matter? We also have what we call monetary jurisdiction. When we are talking about monetary jurisdiction, how much is the limit of a particular court? When I mean how much is the limit of a particular court, if you have a case and it involves a particular amount of money, is there any amount of money that it will reach? I will say, okay, let us not go to this court, let's go to this court. Yes, in most jurisdictions, when I use this in most jurisdictions here, I'm using in most probably states or most cities. So most of the times we use jurisdiction in the territorial sense. So when I say in most jurisdictions, okay, let me not confuse you. In most states, their magistrate courts have monetary jurisdiction not exceeding 10 million naira. What does this mean? It means that if you have a problem that exceeds 10 million naira, you enter into a contract for more than the amount that is involved in the contract is more than 10 million naira, you now know that we cannot go to magistrate court. However, there are some exceptions. So when we're talking about tenancy and landlord matters, when we want to look at or determine the monetary jurisdiction of the court, we will be looking at the annual rental value. What is the annual rental value? What is being paid yearly? If what is being paid yearly is above 10 million, then you cannot go to the magistrate court for your landlord and tenant matters. However, if what is paid yearly is not above 10 million, but this person has been owing arrears of rent for more than 10 million, what do I mean? Let us imagine that the rent is 7 million per year, and this person is owing for 2 years. How much is that? 14 million. So it has passed 10 million naira. So can't you go to the magistrate? No, you can go to the magistrate. Because what we are looking at is not the arrears of rent. What we are looking at is the annual rental value. Is it past 10 million? I'm using the Lagos Magistrate Court law, Lagos. Go to section 28, you will see it. Is it past 10? I mean, the annual rental value. That is what you look at in order to know whether it is the magistrate that has jurisdiction or not. Even if the person has owed for 10 years, that is 7 million for 10 years, that is 70 million, the magistrate still has the jurisdiction. Why? Because we are looking at the annual rental value, which is not up to 10 million. If the annual rental value is up to 10 million, then we know that we are not going to the magistrate court. We do not have that jurisdiction. These are the things you have to know. We have to know the jurisdiction, the court that has the powers to hear the particular matter you are going to. So that's monetary jurisdiction. Now we also have what we call procedural jurisdiction, or jurisdiction that has to do with procedures. How are we supposed to bring this matter to court? When a matter is contested, or when it is contestable, or when there is a dispute on facts, it is disputable. How do you bring the matter? You bring the matter in a particular way. You bring the matter through writ of summons. Now, if you are expected to bring a matter through writ of summons, and you don't bring the matter through writ of summons, you brought it through originating summons or originating motion, it will be a problem, because you have not invoked the jurisdiction of the court by your processes. So when you file your processes and you file it appropriately, your processes are the ones that are expected to be filed for that particular subject matter, then that is when the jurisdiction of the court can now be invoked. However, when you now say you want to do a particular matter, and you now use the filing or the originating process of another kind of matter that is not that matter you want to institute and file, then the court, you've not woken up the jurisdiction of the court. So the court does not have jurisdiction on that matter. Procedural jurisdiction. Look at the case of Mmadokolo against Nkem Delem. That is where the court beautifully lined up the conditions a court must have, or the conditions that must be fulfilled in order for a court to have jurisdiction. Number one, that the subject matter should be within the jurisdiction of the court. That is, the subject matter is very important. The subject matter is within the jurisdiction of the court. It's very important we look at the laws in order to know if the subject matter is within the jurisdiction of this court. Number two, we have to also look at the process by which we filed this matter. We have to look at, are the necessary parties or the parties supposing to be in this matter, are they the actual ones there? Because if the parties are not there, then the jurisdiction of the court cannot be invoked. Then you also look at, is there any condition precedent? Is there anything that you are expected to do before you institute that matter? It's called condition precedent. When there is a condition precedent before you institute a matter, and you do not do the condition precedent first before you institute that matter, then the court will not have jurisdiction. For example, if there is anything in your contract that says you must first resort to ADR before you go to court, you must first go to alternative dispute resolution, maybe arbitration or conciliation or other things, before going to court, and dispute arises, and you do not go to the ADR, you just went straight to court, the court will not have jurisdiction to hear that matter until you must have exhausted ADR mechanism that was provided for in your contract. So that is condition precedent. So you must have to fulfill it. So if you read the case of Omado Koloma against Nkem Delem, you will see it is a locus classicus. When I mean a locus classicus, it is an authority, a very great authority that defines the conditions before a court can be clothed with jurisdiction. So we have not looked at that. Now, jurisdiction can be classified into original and appellate jurisdiction. Original, appellate. From the name original, the origin. How can a matter be instituted in this court for the first time? Is it that this court has jurisdiction for the first time? Now, there was something that somebody was telling me. He said, if Supreme Court has the highest say, or the final say, that this was a neophyte in law. The person, he was just coming into law. He just heard about Supreme Court. He said, what if you just carry every matter to Supreme Court? Why not? Is it not going to save a lot of money? Instead of going from this court, they will appeal, go to this court, appeal. Why not just go straight to the Supreme Court? That is how you now know people that are coming into this law for the first time. People that don't know about what we call original. Now, original jurisdiction is which court has the powers to hear that matter for the first time. If you have a dispute with me, can you carry the matter to the Supreme Court? Yes, the Supreme Court has the highest power, but they don't have powers to hear that matter for the first time. Original jurisdiction. When you go to the Constitution, you will see the matters that the Supreme Court has powers to hear for the first time, in which they have the original jurisdiction to hear. Matters between states and states, matters between the Federation and states. Then you now go to the Supreme Court Additional Original Jurisdiction Act 2002. You will still see some of the matters that the Supreme Court has original jurisdiction. Not every matter. How about the Court of Appeal? I will still come to the hierarchy of courts. How about the Court of Appeal? There are still matters they have original jurisdiction to hear. Matters that has to do with the election of a president, if it's in dispute. The presidential elections is in dispute. You go to the Court of Appeal to talk about whether the seat of the president is vacant. You go to the Court of Appeal, original jurisdiction, the first place a matter can be brought to. Then we have appellate jurisdiction. Appellate jurisdiction is, now we are in High Court. Where do we go from here? If you don't like the outcome of the suit, where do you appeal to? Can you appeal from the High Court to the Supreme Court? I don't want to go to the Court of Appeal. Let me just go straight to the Supreme Court. Can you do that? No. Because from the High Court is the Court of Appeal that has appellate jurisdiction to hear any matter. From the Court of Appeal, it is the Supreme Court that has appellate jurisdiction to hear the matter coming from the Court of Appeal. So you cannot say, let us jump this one, let's go to this one. It will be struck away. They might even imprison you because they will say you are not a lawyer. Because how can a lawyer that went to school, studied 5 years, did 1 year law school, will leave Court of Appeal and appeal straight from the High Court to the Supreme Court? They might even detain you and investigate whether you actually read law. So that is original and appellate jurisdiction. Now let us go into hierarchy of courts so that you will understand the appeal process. I wouldn't know whether I would call it the lowest, but customary court in the south, area courts in the north. Let us put them at the lowest part of the cadre. Customary court, area court. Now the reason I would say they are the lowest is most of the times the judges, if you like, in these courts are usually not legal practitioners. They are just people that are knowledgeable in the customs and traditions of that area. Even though this period now, legal practitioners are actually the ones there. But even though somebody is not a legal practitioner, but knowledgeable with customs and all that, then he can be a judge in these customary courts or area courts in the north. Now, above that, we have the magistrate court in the south and district court in the north. Now, It's not as if the North does not have magistrate courts, but most of the times, magistrate court, but this is now going deeper. Magistrate courts in the North are usually courts with criminal jurisdiction, but let us not really go into that. But just have it that magistrate court is like the second highest in the cadre. Now, when you now go higher, we now see high court, state high court, federal high court, court martial, national industrial court. All these courts are courts of coordinate jurisdiction. Listen, hey God, all these courts I just mentioned, state high court, federal high court, NIC, that's national industrial court, court martial. All these courts are courts of coordinate jurisdiction. What do I mean? It means that they have equal powers as it concerns powers. You will not be asking, state high court and federal high court. Federal is not higher than state. What are you now talking that federal high court and state high court, they have the same jurisdiction? Yes, that's what I'm talking. Federal high court and state high court, they are courts of coordinate jurisdiction. You cannot appeal. This is what I mean. I mean that you cannot appeal from the state high court to the federal high court because they have equal powers as it concerns powers. Their powers are equal. You cannot appeal from this one to this one. This one does not have the powers to set aside the judgment of this one. They have coordinate jurisdiction. National Industrial Court also has coordinate jurisdiction with the state high court, and also the court martial has coordinate jurisdiction with both the state high court, federal high court, and the National Industrial Court. Now, from the National Industrial Court, where will you appeal to? What is the highest, the higher one in the cadre? We now have the Court of Appeal. The Court of Appeal. Now, from the Court of Appeal, we now go to the highest, which is what? The Supreme Court. From the Supreme Court, where do you go to? You go to God, because Supreme Court is the final court in Nigeria. If you don't like the outcome of the Supreme Court, you have to manage it. There is no place you're appealing to except to God, for people that believe in God. So that is the hierarchy of court. And the reason I gave you this hierarchy of court is to know who to appeal to. But of course, customary courts, they don't really appeal to the magistrate courts. Yeah, we have what we call the customary court of appeal. Sorry, I forgot to mention also, in the coordinate jurisdiction, the state high court, the federal high court, the national industrial court, the court martial, also the customary court of appeal is also in the same line with high courts then. So from customary court, you appeal to the customary court of appeal. Not court of appeal, CCA, customary court of appeal, which has the same powers with the high courts. Now, if it is a customary court matter that you appeal to the customary court of appeal, then from the customary court of appeal, where do you appeal to? To the court of appeal. Because customary court of appeal is in the same level with the high courts. And where do high courts appeal to? To the court of appeal. Which means, if the customary court of appeal is in the same level with the high courts, they will appeal to where the high court is appealing to, which is where? The court of appeal. Then, finally, to the Supreme Court. However, when we talk about the National Industrial Court, their appeals end at the Court of Appeal, especially when it is civil in nature. If you have not watched my video on criminal and civil law, you are doing yourself. It's not me you are doing. Go to the classifications of law. I explained civil and criminal law there. So, especially if it is under civil law, National Industrial Court matters. Once you start it there, you appeal to the appeal court, it is finished. You cannot go after the Court of Appeal to the Supreme Court. The Court of Appeal has the final say in that matter. Also, when you are trying to appeal the decision of the National Assembly and State of House of Assembly Election Tribunal, so when you contest for National Assembly and you contest for any legislative position, of course, national or state, and you lose, you sue. You know how they do it in Nigeria now. You bring an action, you sue INEC, you sue, and all that. And you don't like the decision of the tribunal. Maybe the tribunal says that it's that person that won. Where do you appeal to? You appeal from that tribunal to the Court of Appeal. In this particular matter now, the Court of Appeal is final. It has the final say. You cannot appeal further to the Supreme Court. However, Governorship Election Tribunal, you can appeal further to the Supreme Court after Court of Appeal. So I don't know if I'm now confusing you, but let us take it easy, jejely and jejely. So we're talking about jurisdiction. We've talked about original jurisdiction. We've talked about appellate jurisdiction. We've talked about court of coordinate jurisdiction. We've talked about monetary jurisdiction. We've talked about procedural jurisdiction. We've talked about territorial jurisdiction. We've talked about subject matter jurisdiction. So learn about jurisdiction. It is very important, especially if you want to practice law as a litigation lawyer, because your ability to know the particular courts that have the jurisdiction will contribute to your success as a lawyer. Because imagine you get a client and you want to institute a matter, you institute the matter in a court that does not have jurisdiction, and after all the money your client has paid, the court will not strike out the matter because the court does not have jurisdiction. It's an embarrassment on your own part. Your client might just say, nah, this lawyer does not know what to do. You don't want that. You want to read and know the meaning, the jurisdiction and the hierarchy of courts. So I hope you've learned something new today. Comment in the comment section your questions. I will be happy and very, very enthusiastic to take your questions and to give you very good answers. Until we meet again, keep reading, keep studying. Take care.